Collins, attorney with Smoky Mountain Legacy Partners. Our goal today is going to be to give you an overview of how we help clients prepare for that lifetime of protection, guidance, and support. And kind of the focus that we like to have is we want to make sure that the delights your children with special needs experience in the world today can continue throughout their lives. And we also, as I mentioned, we want to make sure that caregivers are well supported and well prepared to face challenges that you've maybe already been through. But we always want them to, those caregivers who may step in to assist us, or when we're no longer here, that is part of what we'll be talking about. So that, you know, they always have some time and energy to take that delight in our child that we take today. So we feel like the best way to achieve those goals is by aligning your financial and legal plans as components of a comprehensive special needs plan. So I went to law school to focus on juvenile court work. And then years later, this young man here changed my life when I became his adoptive stepmother instead of just his stepmom. And he is a young man with autism. He goes by Super Jacob to most everyone, and sometimes that's even what I'm to call him. But he truly is Super Jacob, and there's so much delight that we take in him that we really want to make sure that when we're not here, or if we have some disability that we develop ourselves, that others will step in and be empowered to step in to make sure that he still gets to go to Monster Gym occasionally, or, you know, things that he counts on. Just today, I got a text from him that said that he's obviously watched about a TV news story about the carrots that are making people sick with E. coli. And so he said, carrots are supposed to be healthy, not make us sick. Can you please make sure to get carrots that do not make me sick? And that's just one of the examples of the kind of delight that he gives me in this kind of a concrete way of looking at things, but he just cuts right down to the important part. So we want to help all parents face the reality of their own death and potential disability someday. And we want to face that with clear eyes and an open heart, and help them make the right choices for their individual families. So let me go to the next slide. I am a special needs parent, but I'm also an attorney, so I have to throw this disclaimer out there. I'm just providing general educational information today. Every family situation is unique and deserves legal counseling specific to that family. So please keep that in mind. Now we're going to start with kind of the basic issue that all parents face, is that if something happens to us, to parents, children would receive an inheritance of any assets that we have. And at 18, they would just get those outright. Now, perhaps some of you can remember, as I vaguely can, what you were like at 18. That's not good for anyone to receive assets at that age usually. But it's even more crucial that children with special needs have parents who have addressed this issue, because those inheritances or even gifts, you know, family members like to write that check maybe for a graduation gift. And if the child is receiving government benefits such as SSI, which is supplemental security income, and very importantly, TennCare, which provides a lot of support for individuals with special needs, especially during that transitional phase. Well, if they're getting those government benefits and they inherit anything over $2,000, then they're going to be disqualified. Now, there are some ways that we can go in and salvage that situation, but it's going to have impacts on our family's assets. And I'll explain a little bit more about that later. So this is kind of the situation that we're trying to proactively prevent, is children receiving assets outside of a trust.
Before it's too late. Oh, and to outlaw the legal mumbo jumbo you have to go through for conservatorship.
I think someone has their mic undone or on. So I was hearing some talk there. So let me know if I need to take a break or anything. Um, so this is one of the issues that is faced as many parents come and they say, well, we have a plan. We're going to leave assets to a child's sibling or something. But what parents need to be aware of is that if that child that they leave money to take care of a sibling is divorced, falls into debt, develops their own disability, those assets are going to be used for them, be required to be used for them. And then upon death, their heirs would have a right to them, not necessarily their sibling with special needs. So that is not always the best plan. A critical component of of special needs planning is to be aware that even if you have nominations in your will about who would care for your children, if something happened to you, if you were just temporarily or on a longer term basis disabled, your will would not be in effect. So we need to have those nominations in a power of attorney or some other type of kids protection plan to make clear who we would want to have custody of our children if something happened to us. And there might be someone in your family that would step forward that you would not want to have custody of your children. So that's something we also think about. Another thing that we look at is with, and I'm going to try to go through a lot of this pretty quickly because I know that there's a lot of interest in the conservatorship and supported decision-making options. So I want to save extra time for that. But because some families do give gifts during lifetime, or children may earn some money, or they may want to save up their SSI. Well, they really cannot do that. They, if they're going to be getting those long-term services and supports through TennCare or receiving SSI, they cannot have more than $2,000 in assets in total. And so one of the ways that saving can be done for a child with a disability is to use an ABLE account. And there are some resources in the chat that will allow you to explore ABLE accounts a little further. Tennessee has an ABLE account. And every state, I think every state has some form of ABLE account. Some states have more than one. Some have options like setting up an ABLE link card. The ABLE Now Virginia account has that. And it allows children to go out and make purchases. And this is not right for everybody, but for some, it's a tool to help them build autonomy. A parent or conservator can set limits on what they can spend at what location on this card, and yet they can, just go through and swipe a card like anyone else if that's an appropriate thing for a particular child. Some of the important things to know about ABLE accounts is the disability must have developed before age 26. That is going to change to age 46. Then, so there's no disruption of supplemental security income if the balance remains under $100,000. You can choose your own investments. It's like an investment savings account that is invested. The fees are minimal. And the important thing, some people will say, don't use an ABLE account. But the reason they say that is because the generic rule is that the TennCare agency or the Medicaid agency has to go back and take anything that's left in that ABLE account when that individual passes away, instead of it passing on to family members. Tennessee has eliminated that Medicaid payback provision for ABLE accounts so that the individual who owns them can designate siblings or someone else in the family who would receive that. So it makes using an ABLE account in Tennessee a little bit more of an effective method. It also can pay rent for individuals through an ABLE account without reducing SSI. And it's also the one thing that can hold both family gifts, the one type of account that can hold both family gifts and an individual's wages. So that's important to know. Now, those only 18,000 per year can be contributed, and I don't know many people who are doing that donation of 18,000 per year. But it's still important to recognize that, because that $18,000 limit is why we can't just use an ABLE account to hold an inheritance that we're hoping will get our child through the rest of the decades after our death. So, okay, here's going to be some of the most important part that many of you may have come for. The time when many parents begin to focus closely on this is when a child is about to turn 18. That is when they become their own household for supplemental security income purposes. Until they turn 18, their parents' income is deemed to them. So if the parents are making basically a living wage at all, then they won't be eligible for SSI. But when a child with a disability turns 18, as long as they can document that disability, get a disability determination from Social Security, then they become their own household and they will start receiving that SSI payment. Right now, I think it's $943 per month. It's going to go up to $967 next month. While that money is very important and makes a very big difference, we also see that that's not going to be enough to sustain a person. And that's why we do emphasize these alternatives for saving for a child with a disability. But the other thing that comes up at age 18 is that parents lose access to medical and educational records, and they lose decision-making authority for their child. And this can be a real problem for many parents, because they're used to making those doctor's appointments, to making decisions about what medication works best, to even administering those meds and things like that. So that's the biggest reason that we might consider a conservatorship. That's one way to approach it. Another way is if your child has the capacity to, well, it's the capacity to contract, but the capacity to understand a transaction like a contract sufficiently. I may have to get a drink here in just a minute. Then they can sign powers of attorney themselves. And that's an alternative way that a parent can still provide support for the child in their financial or legal matters, or in their healthcare decision making, or healthcare. We all have to deal with insurance. So the child can actually can empower the parent to help them with that by signing a power of attorney. They do need to have capacity to make those decisions, though, in order for those documents to be effective. Give me just 1 minute to take a drink really quickly. So the other issue that causes many parents to consider conservatorship is, and what I encourage parents to look at, is how vulnerable is your child to financial exploitation? Could they have an acquaintance who will, take them down to, I don't know, somewhere shopping and have them fill out a credit card form? If someone asked them to buy something for them, would they do it just because they're wanting to please that person? Or would they feel empowered to say no? That's one of the big reasons that parents can choose a conservatorship. Another issue is that if a child does powers of attorney and goes the supported decision-making route, all they have to do is say, I revoke it. Now, technically, they perhaps should do that in writing, but if a child says they revoke it to anyone, then it can't be used in the future. So if there's some volatility in their decision making, that can be another reason to consider conservatorship. Now, there are a few requirements for conservatorship. One is that a a physician or a psychologist is going to have to make a recommendation to the court that the individual needs that conservatorship. And so, it's not going to be just the parents or just the parents and the child deciding. There is going to need to be a medical or psychological opinion. Then if we get that opinion recommending the conservatorship, we can file the conservatorship. We usually want to have that hearing as close to or on the 18th birthday as possible, so there's not a gap period where problems could come in. And then this is a very difficult decision for some parents. And so I think it comes down to, for every child, finding that balance of protection and autonomy that best serves them. And one thing that I really focus on with my clients is, even if you decide your child needs the protections of a conservatorship, at least for a transitional period or permanently, still, I think it's a moral a moral choice for a parent to always be trying to maximize that child's autonomy, even within a conservatorship. And one of the tools for that, I'm going to try to bring that up where you can see it. Give me just a second. There's a website that can help you kind of sort through some of these decisions. And it's called the Center for Decision Making Supports, Tennessee Center for Decision Making Supports. And that link is in the chat. And then this particular tool called Charting the Life Course, I think it can be used whether you're doing only supported decision making, or I think it's a good idea to use it even for parents who have a conservatorship for their young adult, because we always want to be saying, what's the next step? You've been through the IEP meetings where we say, what are our goals for this year? Well, I think it's important to continue that, to continue having the young adult to grow into making as many decisions as they can. So you see how here there are these different categories. We have daily life and employment, healthy living, social and spirituality, safety and security, community living, advocacy and engagement. And for each of these sections, we identify, is this something that the young adult can decide with no extra support? Is this an area where the person needs support with their decisions, or do they need someone to decide for them on those decisions? I think it's worth going through this form at least once a year, just to see, what are the right next steps for my child. Now I will take that down. Hopefully you can see the transition to adulthood screen again. I do encourage all parents to go to that. You can just Google Tennessee Center for Decision Making Support if you don't happen to grab that out of the chat. They have a lot of the pros and cons of choosing a conservatorship or choosing supported decision making, or honestly, what I kind of lean to for a lot of individuals, certainly not all, is kind of a combination of the two. So we will see. You may have questions on that more in just a minute. So the next step in a special needs plan is to make sure that we're maximizing those public benefits. An example of this is if you give your child free housing, as many of us do when they turn 18 and they have any sort of disability, they probably need that extra support of staying at home for some. If you don't charge them rent, then Social Security is going to reduce their SSI payment by 1/3. They call that in-kind maintenance and support. So the more effective way, now there are some families that are perhaps they have sufficient resources that they are not worried about that 1/3 reduction. But as we've mentioned, it's very hard to make it on the $943 a month right now already. It really probably costs more than that to live, even with them living with you. So If you are providing them with housing, you can enter into where they pay a fair share, like the proportion. If let's say there are 4 adults that live in the home, then their share might be a fourth of the mortgage and the utilities that they would pay. If families have already paid off their mortgage or own their home outright, then they might want to enter into a rental agreement with the child, and either of those can prevent that 1/3 reduction. An ABLE account also, let's say that the child wanted to get an apartment somewhere, and that was what the family agreed on. But the family needed to supplement that, because there are not many places you can rent for $943 a month right now if they were going to spend all of their SSI on housing. But if the parent were to pay, say, half of their rent outright, then Social Security is going to say that's a gift. That's going to reduce their payment by that 1/3, or they might count it just outright as a gift and take the full amount of the gift off of the payment. Because that's another thing. If anyone gives your child cash or anything that can be used for their support for those basic needs that SSI is meant to cover, if they give that to them directly, it is going to cause a reduction in their supplemental security income for that month. Now, the important thing to notice is that you may say, well, I don't really care if my child gets SSI at all, but it may be crucially important that they get TennCare. TennCare provides what we call long-term services and support, or home and community-based services that can be absolutely essential, especially during that transitional phase from childhood to adulthood. Some of the things that long-term services and supports provide through TennCare are day services, job exploration and coaching, which can be very vital, residential services, respite care, community integration, personal care assistance. Now, each individual on those programs has a certain budget, that none of those are unlimited. But you have to receive at least $1 of SSI in a month to qualify for TennCare on the basis of disability. So that's why preserving that SSI is so important. Now, later on, after your child has perhaps worked for a while, they may earn enough to be entitled to a certain proportion of that being SSDI. That does not have those same restrictions that SSI has, because it's an earned benefit. When you retire, or if you develop a disability and you start drawing Social Security, then your child will receive disabled adult child benefits through Social Security. And with retirement or disability, I believe that amount is 50% of whatever the parent draws. Or when the parent passes away, then the child will get 75% of the parent's, whatever the parent's benefit is under Social Security. That doesn't mean it's taken away from the parent, but it does mean that because it's not, the parent still gets their full payment. It just means the child is provided that in addition. It's based on a benefit that the parent has worked and earned. So there's not that reduction based on charging rent or not charging rent. And there is still an exception that still allows the child to remain on TennCare as long as they would otherwise be eligible for that SSI, but for the fact that they're receiving the disabled adult child benefits, or SSDI. I hope. It's really hard to grasp all of that. To be honest, it took me over half a decade to really get comfortable with understanding all of that. So don't fret that you have to memorize all of that today, or that you should get it immediately. One other thing I'll throw out there is that when a child's receiving those disabled adult child benefits, or SSDI, after a period of 2 years, then they're entitled to Medicare. And what I want to note about that is that will cover their health care. There will be some premiums for certain parts of that, and that's way too involved to get into today. But Medicare does not cover those long-term services and supports that many of our children with disabilities require. Again, those day services, job exploration, job coaching, certainly any residential services, community integration, those things. So maintaining that eligibility, even after the child's not on just SSI anymore, maintaining that eligibility for both Medicare and Medicaid can be vital for many individuals. Other benefit programs include Section 8 housing, other grants through HUD, or veterans benefits. So all of those we want to try to make sure that the benefits that our government has collectively decided to make available to our children, that we take advantage of those, and help them get the support that our society has decided that they should receive. And then but we're going to need to supplement that in most cases with what we can provide through our own resources of the family. One important thing for a family with a child with special needs can be to create a financial plan, identify both the support needs and the sources, get an idea of what would your child, not just what does your child need now with you alive and providing assistance for them, but take a realistic look of what they will need when you're no longer able to provide the support that you currently do. So we want to look at both public and the family sources of support, and then consider how we're going to supplement those with that ABLE account or a special needs trust. So developing a financial plan, considering inflation, taxes, and a need for life insurance can be a really important part as well. Now, a big part of what we help families with is establishing a special needs trust. Again, because that annual maximum contribution to an ABLE account is $18,000, even if a parent just has a home that's going to be sold when they pass away, to provide ongoing support for an individual, then they can't receive that without it potentially disrupting their benefits of whether it's SSI and Medicaid, or if they're on SSDI, then just the Medicaid. Now, there are some exemptions. A house happens to be one of those, but by and large, many families need to use a special needs trust to avoid disrupting benefits. One of the key benefits of setting up a third-party special needs trust in advance, third party means that someone other than the individual with special needs has provided the funds. In most cases, that's the parents. They're setting aside a certain amount, or an inheritance, or whether they gift it during their lifetime. They're a third party to that transaction with the child. So because it's really the parent's money that's being preserved in that trust, there's no Medicaid payback clause. If the child inherited assets without it being moved into a special needs trust, which was set up in advance of the parent's death, there can be what's called a first party special needs trust. And what's going to happen then is when that child passes away, anything that remains in that trust is going to be taken by Medicaid. They're going to recover dollar for dollar everything that they've ever spent on that individual before anything goes along to maybe those caregiver siblings that have stepped up and have been caring for the child for decades. I do talk about this a lot. I'm a big believer in these because, so many of our children with special needs, we're going to need to set aside a larger portion for them instead of just dividing things equally among the family members. Or so what those caregiver siblings that are going to have these additional responsibilities are faced with is they're receiving a smaller inheritance. They're also taking time away from their own families and careers. Now I'm a firm believer that all of that a caregiver sibling does, it makes them, it's a reward for them in many senses, but it does have a financial impact on their family. So wherever the family can preserve family resources by means that, our government, our society has collectively decided is permissible, I think it's a good idea to consider that. Because to me, it's a recognition of our society that these families do have extra challenges and need to have ways to preserve those resources for family members. Um, there's also what's called a pooled special needs trust, and that's if you um, have maybe a small amount that's going into a special needs trust instead of having an individual one with sometimes higher expenses, depending on if you have a corporate trustee or if you have a family member who's going to be managing those funds, then there's not so much expense. But sometimes there's not a family member to manage funds. And so a pooled special needs trust can be the right choice for that. Okay. Um, so then the next step in a special needs plan is facing your own potential disability. We certainly, most of us, we might go and ask an attorney for a will, but in families with children with special needs, we do have enough challenges already that we want things to go as smoothly as possible, no matter what happens. So, having those powers of attorney in place for the parents is important. Using that will or a living trust to direct assets to your children, having all of that organized and in order gives whoever's caring for your child or providing support during a period of your death or disability, it's like you're smoothing the way for them, smoothing the path, because they're going to be helping your child deal with grief or just meet the challenges of daily living during that time. Those transitional periods are hard, so we want to make those as smooth as possible. Updating beneficiary designations is important as well, and considering a parent's own potential for long-term care needs. So here is one of the big things that I emphasize, and this does come a lot from my own experience, and it's an area where our family is very fortunate. Our son has 3 sisters and cousins and grandparents who are involved, and I meet so many clients who do not have all of that involvement. And sometimes we need to build networks with each other. I would always want someone to be, especially if my son was in, whether he was in a day program or residential living services, I want there to be somebody checking in on his well-being if I'm not able to. So we try to help lead clients through considering who is best suited for each role. There may be a cousin who would just come to an annual circle of support meeting and provide their input about what this young adult, or what this, doesn't matter the age, what this individual most enjoys. Now, of course, if the individual with a disability, if that disability is primarily a physical disability and not intellectual, then they're going to be there advocating for themselves. And even people who certainly do have some degree of intellectual impairment, even substantial, they should always be consulted and have input into what the plan is for them. But for many of us, we want there to be family members, friends, other people to give support, make sure that those caregivers, whoever steps up in our role, because we know how hard that is, we go through some difficult seasons. We want them to have a broad team of support to the extent that we can find that. And we also work on a circle of support and fiduciary manual. This is a 12-part form, basically, that parents fill out. And it covers everything from, who their TennCare support coordinator is, what safety mechanisms need to be in place in the kitchen at the home, what safety things need to be in place in the bathroom at the home. Does this person need to be prompted to brush their teeth and take a bath? Do they need help with that, or do they do that fully independently? Just a place to record things like that. I also find it beneficial for parents to record, if your child has been through the grief of losing a grandparent before, recording some of the techniques that were helpful to help that child through that then could be very important for a future caregiver to support them in a better way if something happens to the parent. So you may have also heard of these called a letter of intent or a memorandum of intent. Um, so we're coming to the end here and a time for questions. We also, you might have noticed the name of our firm is Smoky Mountain Legacy Partners. That doesn't scream special needs, but that has become our focus. We do other kinds of estate planning, but kind of the heart of our work is helping people take care of vulnerable family members. And I see an important part of that. An important part of our legacy, maybe even far more than any financial assets we could leave, is how much can we build that team to support each other. And that's one of the things that we are focusing on in our own family, helping our children learn to support each other better and recognize, oh, this person's having a hard day. I need to step in with a little more help. Um, so we record often a legacy interview where parents can pass along some of their um, intellectual and spiritual values, some of the things they've learned, hard earned wisdom and cherished memories, and just be able to express their love for their child when they're no longer available to express that in person. Um, So kind of the focus of our work is around that transition to adulthood. Also, when people move into Tennessee, conservatorships need to be transferred between the states. And it's a good idea for clients nearing retirement to review their own long-term care planning, exactly what would happen. I know many of us feel, well, I throughout my life have had some resistance to working with a financial planner or something like that. I'm like, there's nothing to manage except student loans. I think that's a case for a lot of people with law degrees these days. But anyway, we do need to take a look at, okay, what would happen if I needed long-term care, if I had an accident or a medical event that caused me to need long-term care, what really would my family be facing? And that it's really important for families who have a child with special needs of any age to face that reality and plan for it. So I will stop sharing now if I can figure out how to do it and let you ask some questions. Does anyone have any questions?
Yes, I do.
Okay.
Um,
Is this Betty?
Lila
I
Jeffrey.
see Betsy. Just identify yourself if you don't mind, and then ask the question.
This is Lila Jeffries.
Okay.
Uh,
Hi, Lila.
asking, hi, asking, do you recommend both an ABLE account and a special needs trust, or one or the other?
Most of the time, both. An ABLE account, for example, can pay rent for an individual without it reducing their SSI. And that's something, I'm not sure how much I went into this, but if a parent helps a child pay rent, then they're going to reduce that SSI payment. But if the parent makes a gift into the ABLE account that then makes the rent payment, then there's no reduction. So that's one reason. Uh, it really, it can be an individual choice, but they work well together. That special needs trust, most of the special needs trusts that we do are only intended to be funded upon the parent's death. Now, that's not always the case, but that's the most common thing. So that ABLE account is somewhere that the parents can put aside some savings specifically for that individual. Now, if I were in another state that, unlike Tennessee, still had Medicaid payback from that, that may not be a good option. And of course, we can't guarantee that the law won't change here, but there was broad bipartisan support for that removal of Medicaid payback from the ABLE account. So I think it's just a matter of using each correctly. Does that answer your question?
Yes, thank you.
Thanks. I see Betsy Gill has a question.
Yes, hi. Thank you, Shauna, so much for your presentation. I guess my main question is, my daughter does have a diagnosis of autism, but she's very high functioning, and I don't know whether she would need a special needs trust or not. Like, what are the qualifications?
So that is a very good question. If your child ends up not needing government benefits that are means tested, then she may not need a special needs trust. On the other hand, if you were to leave money in some other type of protected trust, because there are a lot of individuals similar to your child who maybe they can make their own financial decisions, but we would not want them to just receive an inheritance outright. So we could use a different type of trust for that. But then if they ever develop that need for those government benefits, that money would have to be spent down, or it would get very complicated trying to qualify them for benefits if they received an inheritance outside of a special needs trust. On the other hand, kind of the drawback of using a special needs trust when you're not sure it will be needed. One of those is the child can never be the trustee, and there are those individuals, you mentioned autism, there are those individuals who may have a strength in financial management someday. Maybe it's not fully developed at 18, but maybe at 25, they're a financial guru of some type, So if you use a special needs trust, they would still never be able to be the trustee and have that full autonomy. Another aspect of a special needs trust is the trustee can never just distribute money directly to the individual. They instead have to pay for the things the individual needs. Now, they can set up what's called a TrueLink card that's similar to that AbleLink card I mentioned, where the individual can use a debit card basically to make certain purchases within limits established by the trustee. So it can be a hard decision at times. I tend to, and this may be because of my biases as a parent, I tend to err on the side of being protective of my child and of my resources, because I just, but my child's level of disability may be very different from your daughter's. My son has a substantial intellectual component to his. He's very gifted in some areas and struggles in others. So it is an individual choice, but I tend to err on the side of doing the special needs trust. And if you set up a special needs trust, and then at age 25 or 28 or whatever age, you decide, oh, they've become financially independent. They're just, we don't want to put all those restrictions of a special needs trust on them. You can always come back and change that as long as it's a revocable trust, which is most of what we do. I hope that helps.
So you could change it from a special needs trust to a regular trust or something.
Well, depending on two things, depending on how it's drafted and depending on whether the person who gifted into it is still alive. Like I mentioned, most of the time when we draft these, the parents do not fund the trust in advance. It's sitting there waiting, so that when the parent passes away, either their will or living trust will direct funds into the special needs trust. So it's no problem at all to change that. Once it's been funded, it can be a little more tricky to change it, but in many cases, it can be changed.
Okay, thank you.
Shauna?
Oh, yes.
Recorder here.
Okay.
What happens when a child turns 18, not receiving any SSI, but now TennCare is kicking them off? Is there any way we're having
So is this
battle? They're autistic. I got autistic twins.
okay? So are they And you only share as much as you want to here, but I will tell you some of the things we will look at, maybe instead of asking you these questions, because we would need to address that separately. So kind of what I would look at first is whether you applied for that Social Security disability determination. Again, they only need to draw at least first, they need to get the disability determination. If they have a disability that makes them incapable of what the terminology of the Social Security Administration is substantial gainful activity. Now, if they don't qualify that, that puts them in, if they don't qualify for under that definition and through those criteria of Social Security, that puts them in a difficult position because maybe they have the ability to work a certain amount, but they're not fully independent either. And that can be very difficult in terms of finding health care for individuals. They may still qualify under some other program of TennCare. I would look at the Tennessee Justice Center is a great resource for access to TennCare, and they might be able to help you identify any other program that the child might qualify for, maybe perhaps some transitional care. But sometimes parents hesitate, and I'm not saying this is you at all, but I do see this where parents say, well, we're not really that concerned about them getting Social Security. We're providing for them. And I respect that fully, you know, but it's my job to educate clients about the impact of that decision not to seek that disability determination. And one of those is not having access to TennCare in most cases. And then another is if you have retirement accounts that you're hoping to pass along to provide support for your child. Most children have to take everything out of those accounts within 10 years. A child with a disability can stretch those retirement payments, required minimum distributions over their entire lifetime. And that can make a really big difference. So that's another example of where that disability determination can have an impact. So I think the first thing I would look at is whether your child would qualify for that disability determination. And so I would want you to consider whether you need to apply for Social Security, supplemental security income for them.
Can I just give you a call?
Yes, you can.
Okay.
If you want, I will put my firm's number in the chat. Give me just a second. And you'll probably have to leave a message for me, but we'll get back with you and we can discuss that a little bit further since that's going to involve your personal information.
Okay, thank you.
I see Berland Gibson has a question, I think.
Yeah. So I think you hit on some of the things. I think I need to do that checklist, but that would be great to have. I started the process, and we kind of stopped. My son is 18 now. And when we went to get the paper verified, like the paperwork from the doctor, she, her response to me was, asked him if he wanted the conservatorship. He obviously said no. And then she said she didn't see enough documentation, but I provided her with documentation. And so we kind of stopped the process. So because I'm in the SPED world, I have done so much for my child. So I kind of looked at her and I said, so you're punishing me for being a good parent and making my kid functional in society. But there's still some, like you said, some cognitive things that he's unable to make decisions on his own, and his working memory, all that stuff, that if she looked into it, would see that he still needs help in making those decisions. But it's funny enough, when I turned around and I told him, okay, so you're responsible for all your appointments, are you this, are you that? He's like, I'm gonna need some help. And I said, well, this is why we have this. So I didn't know about the decision-making part. So how do I start back this process if he is 18 and there are significant things in his health history that would show that decision-making he can be taken advantage of. He can't make those big decisions on his own. How can I restart this process if he is 18?
So So you could talk with him and meet with an attorney with him. And of course, that doesn't have to be me. I would encourage you to go to an elder law attorney at least, because they're going to understand. Elder law attorneys have additional training or knowledge about various benefits and these sorts of issues. But you know, you could sit down and have a conversation with your son with an attorney, exploring whether he wanted to sign those financial powers of attorney to you, or the healthcare power of attorney. And of course, he can revoke those at any time, but that would still be a way for him to empower you to continue providing that assistance. And then you might use the charting the life course tool to sort of help him grow into those. I might, as parents, we often are going to have the preference to provide the protection and have the autonomy be second. I will say that when a conservatorship is challenged, the child has a right, or the individual who would be the ward, they have the right to an attorney ad litem to represent what they want, in addition to a guardian ad litem to represent their best interest. If it's an agreed conservatorship and the parents are applying, then the statutes do allow in Tennessee that the court waives the guardian ad litem. But if there is an individual who doesn't want to have a conservatorship, they're absolutely going to get the guardian ad litem. And then if the guardian ad litem attorney to represent their best interest agrees that even if they agree with the parent that they need that conservatorship, the child's going to have the right to have another attorney appointed to represent what they want. And that's going to get pretty expensive, possibly. So you may want to pursue that supported decision-making route and do those powers of attorney. It's a difficult choice sometimes. These are not always easy solutions, but the best way is to, be in partnership with your child, with their healthcare providers, to see how you can work best together. And, sometimes we can explain to an individual who doesn't fully have the capacity to protect themselves what they're risking, and they don't fully get it because they don't have the capacity. And that's where sometimes a parent might have to make that difficult decision to go that route of a contested conservatorship. Our firm does not handle contested litigation. Maybe someday we'll be able to. But sometimes that needs to happen. Does that help at all?
Yeah, that makes sense. And I've heard the power of attorney part. And I think it's just, I want to be able to help with supporting his decisions, not take over everything, because I think he's gotten a good amount. So that makes a lot of sense. So thank you.
Okay, you're welcome.
All right.
I see a question in the chat. When do you start the conservatorship process and how long does it take? That varies a little bit. Here are some of the time constraints. If we don't want to have a gap at age 18, then we want to have that hearing around the 18th birthday, or as soon after the 18th birthday as possible. We have to file the petition within 60, we have to have the hearing within 60 days of filing the petition. And we have to file a petition within 90 days of the evaluation with the medical person, the physician or the psychologist. So generally you're looking at about a 6-month process. I know that when we saw the conservatorship for our son, it took us over 6 months to even get an appointment with his psychologist. So, to do a full evaluation. And so it really depends on how long that is. So you need to start about a year in advance, but you don't want to make that appointment more than 5 months or so. You want to make that appointment. That appointment needs to occur with the physician or psychologist maybe around 3 to 5 months before the birthday. And then the process, It's usually about 3 to 4 weeks after filing the petition that we have the hearing. It can be that short anyway. And then the parent goes and is sworn in by the court clerk, taking their oath as conservator, and then they're provided with letters of conservatorship, sometimes that day, sometimes it's later. I hope that answers that question. Carter, did you still have another question?
No, I'm good.
Okay.
Thank you.
Okay. Well, I hope that was very helpful to all of you. I appreciate you
Shauna,
joining
I think
us.
there was one more from Micah.
Oh.
She has her hand up.
Okay.
Hi. No, I don't know how to work this, but I was the one that typed in the question about when do you start the conservatorship process. Thanks for answering.
Okay. You're quite welcome. Let's see. I think that is everything that I have. I hope, do go back through the chat and look at some of those links that I shared. All of those can be useful tools in learning more about ABLE accounts or supported decision-making and conservatorships. Sue, I'm turning it back over to you.
Okay, I'm going to give one more minute for people if there's some questions that they have. I'm just going to kind of close things up. We are at the 1 o'clock, so I want to take, responsibility for everybody's time. We are going to have another training in December. We are not sure about the date, but it will be a Monday. It'll be either the second or third Monday of December. Until then, we'll be very happy to have you come back. Thank you so much for joining us. Shauna, I really appreciate it. I know you had a lot of information. I think families really, really appreciate that. So everybody have a great afternoon, and we'll see you soon. Okay, are there people that still have questions? We got a couple that are kind of hanging out, so I wasn't sure.
Yes, will we receive access to the slideshow?
You're on mute, Shauna.
I will try to put together one that I can share with Sue, but I think there's going to be a recording of the whole thing. But yes, I will try. I know that I've given out a version of the slideshow to look at before. So I'll try to find that and provide it to Sue.
Perfect. Thanks so much.
Is there still a question?
I was just going to hang out and talk to you for just a second before we wrapped up. But
Okay. Okay. I'm not sure if they just walked away or what happened, but.
Well, I hope that covered most of what you had in mind and not too much of what you didn't have in mind. I know it was not an asset focused thing, but it's hard for me to separate that out from it because so many people